sent that to Christine. Did she tell you yet?
No, I haven't.
Okay, she said she was gonna tell you. All right, how are we doing, gentlemen?
I think you will be happy.
I'm glad to hear
Yes,
that.
Rick Escobar has agreed to 99% of what Mr. Martin has wanted.
Okay,
The only issue, am I right, Mr. Martin?
If they only had 4 issues, you agreed to 2.
oh,
I went
All
to
right.
law school.
I know.
No math.
yeah, no matter. We get
There's
that.
actually really one I'm not even sure that I'm going to do, but because it involves the lighting issue. I can tell you very simply, this is the issue for Mr. Knox. Mr. Knox, because we knew that part of the evidence had to do with witnesses when they were viewing bodies, they were viewing silhouettes. I think you actually remember that there were at least 2 individuals, I believe Friedhoff and I believe it was Hamilton. Both of them indicated that what they were seeing was a silhouette. What causes that silhouette is that backlighting that takes place when that light hits the individual that at this time was facing Mr. Reeves. And so we had Mr. Knox, who is a crime scene expert, test that in the actual theater under mid-1. It was everything that Mr. Knox did. We went to management and we said, we want to try to recreate the setting. I believe you actually sat in that theater with a mid-1 as well when we did the Stand Your Ground hearing. And so Mr. Knox, because of the fact that in a camera you can actually tell what the lighting conditions are in a camera. And so he wanted to capture that lighting and that silhouette that Mr. Reeves would be seeing if a large person like Mr. Oulson was standing in front of him. And so that was photographed. I think you remember probably in the presentation. It was part of the PowerPoint presentation that Mr. Knox had. And so it was to create that silhouette that not only Mr. Reeves was able to see in this whole process, but other witnesses verified that silhouette process. The only other issues that's tied to that same issue, and to be honest with you, I don't know if I'm going to go through the time that it would take to put this on, but Mr. Knox captured the various settings of light in the theater, mid-1 being the most important, and then he was able to do some measurements from certain points to try to capture what that looked like. To be honest with you, Your Honor, I don't think I'm going to do that. In fact, I can tell the court that I'm 99% sure that I'm not going to go and do that. I think it would probably be very lengthy, and I am not sure that the jury needs that. I think that they are probably smart enough to realize, that it was dark in there, and that they're going to have to take whatever that darkness is into consideration. But the silhouetting, I think, is very, very important because I think that captures the perception that Mr. Reeves had, while he was in there. I believe, if you remember Hamilton's testimony, which was really great and is the backbone of this argument, is that he said, no, I couldn't tell facial features. I mean, I couldn't tell whether, this gentleman had blue eyes, red eyes, green eyes, whatever it could be, or color of hair. He couldn't tell all that because it's a silhouette effect. And if you look at the silhouette effect, man.
Yeah, I'm going to show it to them.
Okay. When you're looking at the silhouette effects, that's what you're seeing. And it's not a highly scientific phenomenon. Everybody knows what backlighting is. It's just, what is backlighting, at that time. And Your Honor, I will tell you, honestly that, we tried numerous previews there at the theater in order to try to capture every, possible backlighting that there wasn't. There wasn't much of a variable at all, and that's one of the things that we checked with Mr. Knox. We wanted to make sure that, hey, this was pretty consistent, so that we presented to the jury that's going to be his testimony.
Okay.
So that's I think the only bone of contention is that one, because I don't intend to.
Mr. Martin?
May I approach John?
Mm-hmm.
And Judge, we've briefed this, you've got, I think, our memorandum of law on this.
And Judge, as far as an exhibit for this particular hearing, I'm going to rely on the exhibit number 5 that I attached to the Daubert hearing that has all the photographs, but so you don't have to dig it out. May I just approach with it?
Yeah, that'd be great, thanks.
Right. You know what this is? It's all pictures.
Yeah.
And those are the ones that are in the PowerPoint. Okay. May I approach, Your Honor?
You may. Thanks.
Yes, ma'am. And 2 cases.
Okay.
May I go ahead and begin, Your Honor?
Uh-huh.
Your Honor, I've handed you exhibit number 5 that was attached to the state's Daubert motion and this particular issue.
Okay.
Those are all of the photographs that were taken by Mr. Knox during the time that they had an opportunity to go into Cobb Theater. Your Honor, what I did for you is Mr. Escobar showed you the PowerPoint presentation. Those are the ones with the yellow sticky. So the yellow sticky on there, just so you can find them, those are the ones that are in the PowerPoint. What I'd like to do, Judge, is we're in the same situation we are with playing the preview, that the discussion that we had as far as recreating and simulations. Now, I understand that this was done at Cobb Theater, but the other issue, and the reason I couched it in the form of the Daubert, is because of the scientific principles that have to be relied on in order for this to be fairly and accurately. And this is what they want to do. This is what Mr. Reeves could see. And that's what Mr. Knox testified. The whole purpose of this is what Mr. Reeves had an opportunity to see. So when you deal with that, what are you dealing with? You're dealing with someone's sight and the eyes, human eyes. And if you recall my Daubert brief, Judge, I went into great detail about how a camera lens is not the same as a human eye. And I gave, there must have been 5 or 6 articles that I attached that clearly indicated that that is not the case. And so this is a Daubert motion in which the defense has the burden of going forward and showing to the court, hey, a camera lens is just like the human eye. And a camera lens is going to reproduce that snapshot that a human eye can. And therein lies the problem, because we know that the human eye is very sophisticated. It is able to adapt to changes in light. It has a peripheral vision that captures ambient light. That's all the articles that I gave you, so explaining how the eye can absorb so much more light than a lens of a camera that is set by the aperture, and it is focused on that narrow beam, and that's what we have here. So the cases that I gave you, which is Pierce and Brown, deal with demonstrative evidence. And the requirement for that demonstrative evidence to be admissible, there has to be that type of similarity where it's not misleading or confusion. So we not only have the Daubert issue, where the defense hasn't proffered any type of testimony indicating that a camera lens can actually recreate what the eye can see, that they have, by presenting nothing, they have failed that part. It's their burden. I have given the court all the information it needs so that you can look at it and see that that's just not the case. So I understand why they can't bring someone in and say that, you know, a camera lens is the same as the eye. It can't. So once we have that Daubert, if that's not the case, then if you look at Daubert, because we have to rely partially on scientific evidence, then we look at whether or not it's actually an aid to the jury. If you can't meet that standard, because the eye's not the same as the camera, and we know that's not the case, then it doesn't aid the jury Therefore, you don't meet the Dauber standard. The other one is that based on Pierce and Brown, exactly what is the criteria? If you're going to use a demonstrative aid, what does it have to be? Let's get past Dauber. We've already talked about that, but they haven't even met those requirements. Again, because the camera lens cannot do it. Now, can we say, okay, it doesn't make any difference. It goes to the weight and not the visibility. Here's the problem with that, Judge, is pictures. Now, I've done a lot of cases. I know pictures. I have a case that I lost in 1990, the Latory boat wreck with Barry Cohen out at the Walsingham Bridge. I had one picture out there that caused the pictures. That's what they look at. They don't care all the explanation from NASA and everything, or we come in and it's what they see the picture, it's gone from them. So you put that in front of them with an expert that says this fairly and accurately represents the silhouette, then what it does is they take that to heart too much, especially when we all know in the courtroom that's not accurate. So when we argue, well, it goes to the weight, not the visibility, when you're dealing with an expert who's proffering it under the guise of being an expert and I know what I'm doing, then you run the potential of that carrying too much weight and they don't do their job and consider whether or not they're going to believe them or not. And that's the potential, and that's how 403 works. That's always been the potential we have to look at. To what extent is it so much they will just not do their function? If you run that potential, then you really got to think hard about whether or not you're going to put it in front of them. So in this particular case, we also have a situation where the background you can see is not the trailers that were back there. And that's why we get back to the Brown and to Pierce. We don't know at what point, a decision was made. Was it dark? Was it light? Was it dark? Was it half dark? Whatever it was, whatever the flickering on the screen at the decision made, nobody knows. So what they did is they took, and I believe all of them that they want to use or have a white background, they said, okay, this is a silhouette. This is what it looks like. And they put it in the theater. So you not only have that issue, but then you also have the issue, Judge, if you look at, I believe 2 of those pictures have a red line that goes right to the chest. And I talked to is it Doctor? Dr. Knox about that. Oh, that's just a string alignment, it's not trajectory or whatever. Well, what is the jury going to do back there? They're going to see that red line in the picture. They're going to see how the mannequins are positioned. Now, we all know, Judge, that in a simulation, the defendant's version of the simulation can be put forth, and that's not my argument. My argument is that we don't get past the basic requirement of having it accurate enough for the jury not to be misled. So, and then you also have the other one. If you look at the very last picture that they want to do, you have the issue of forced perspective. And when I took the deposition of Dr. Knox, he said, oh, I was sitting there in the chair with the camera and I had it about where Mr. Reeves' eyes was, and of course the nose looks so big and the cheeks, so you have several issues that cause the state's concern that it's not accurate. So that's the reason. That's the reason that they don't meet Daubert, and it's a 403 argument, and they don't meet the requirements under Brown and Pierce as far as doing that type of simulation. So I ask that they be removed from the PowerPoint.
Judge, let's think a little bit about this. First of all, not only did we brief the Daubert issue in this case, but in addition to that, we provided the court with all the transcripts of Mr. Knox's testimony. So the prosecution goes out there, they find some articles, they throw it on their motion, and somehow they think that that's gold. I don't have an opportunity. Remember, they're making the arguments that my experts can't talk about some other study that took place because they don't have the right to test it through cross-examination. Well, let's think about this. He's told you, this is a scientific fact. I gave you these papers, Judge. We don't even know who that person is. We don't know if he's competent. We don't know if he's incompetent. We don't know what school he went to. We don't know. We can't test it. And so, but he just assumes that whatever papers he gave you are correct. He did that, I think, with Judge Lewis in the other Daubert motions. It doesn't work that way. If you think that what we've put forth in the form of sworn testimony, including my client, my witness's credentials, then bring your own witness in. Bring your own person to test that. He has done none of it. And so, no, I think that he has failed miserably on the Daubert issue because he did nothing other than do his little motion and don't get some papers from wherever he got them, and that does not substantiate or refute my sworn testimony from a doctor that has specialized in this particular area of crime scene reconstruction. So, Daubert, I think, is right. I am very comfortable in relying on our memorandum of law of Daubert and our transcripts that we have met that. So let's talk about this. Mr. Martin, he will agree with you that we had lengthy discussions and depositions with Mr. Knox concerning the fact that Mr. Knox would sit in that chair, look at the scene, take a picture, and make sure that that picture actually reflected what he was seeing with his own two eyes. It's a forensic process that is used in photography. He was upset that when it did not reflect accurately and forensically what Mr. Knox was seeing, he would discard that particular photo. He got very upset. Well, where are those photos? I want to see the ones that you discarded. And Mr. Knox said, well, Mr. Martin, if they don't accurately represent what I am seeing, I am going to discard it because I'm not going to use it in a court of law under any circumstances. So this is a demonstrative aid that is so important because their own witnesses have demonstrated to this court that that's exactly what they were seeing. They were seeing a silhouette. Now, we can assume that people know what that means and what that looks like, but we shouldn't do it in a criminal trial, especially a murder trial. We shouldn't assume that these 6 people, or 10 as they are right now, can actually understand what a silhouette is and what it does to the human eye as far as what you're able to see. We're not and Knox is going to not say, hey, listen, this is exactly, you see that face right there? That's exactly what he saw at the time. It's the effect. He is showing the effect of that backlighting on a human body when it was facing Mr. Reeves. That's about all I can tell the court, Your Honor. I think that we're on solid basis here. Mr. Knox is not going to say anything, in my opinion, that's going to be in the form of an opinion that this is exactly what someone sees in a silhouette. I don't think anybody can do that. But I think that certainly the concept of silhouetting and what happens in the silhouetting process is so important for this jury to understand because, again, this criminal case is so unique in that it's Mr. Reeves's perception that's important. We all know, and I know you're going to get mad at me if I say this again, the danger doesn't even have to be real. Think about that. The law does not punish someone as long as they reasonably believe that they're in imminent danger of death or great bodily harm. And the law says, you know what? You could be wrong. The danger didn't have to be real. It's the perception. This case is all about perception. And so we've got to be able to give the jury evidence of that possible perception with reference to silhouetting. It's as simple as that. That's my argument. I think we've briefed, this issue thoroughly. I've conceded to everything else that Mr. Martin wanted, not because he was necessarily correct, but because, I've got to necessarily try to tailor my case as we're getting down to the end to what needs to be presented before the jury.
Could I have 5 minutes?
Yes,
If I promise to keep it 5 minutes.
go ahead.
Judge, the articles are in the Daubert motion so that I can file a legally sufficient Daubert motion. Once I do that, it then becomes the burden of the proponent of the evidence to refute that. That's Mr. Escobar. Now, what they've done is they've ignored that, and they've made a choice. We don't care about that. We're going to rely on Mr. Knox to come in and say, okay, this camera, I looked at it, and it's what I'm seeing with my eyes, therefore, it's correct. And we know that's just not correct. So what we're doing, and Mr. Knox then says, and he has said, this is what Mr. Reeves saw. So that's where we have the problem, is that it's Knox's testimony that Mr. Reeves saw that. Well, what we know about silhouetting, what do we know? We know it's done with the human eyes. And silhouetting is dependent on the differences between light in the background and the foreground. And so if your eyes are different than the camera because of all the ambient light around, then we don't know if there's a silhouette at a particular point in time based on the light in the foreground and the background and the ambient lights from the sconces on the side. There's the problem, is, okay, we want to show this is the silhouette, this is the silhouette, but Mr. Reeves saw. We can't do that because the silhouette is based on all of the light that the eye takes in and the camera doesn't. And once you get to that point, then it's misleading to the jury. And so I disagree strongly with Mr. Escobar that, you know, I needed to do anything. I did a legal, sufficient Daubert motion that they chose to respond in a certain way and they failed because they didn't address those issues. They simply said, Mr. Knox looked at the camera. That doesn't mean it. So that's my 5 minutes, Judge.
Judge, I have 30 seconds.
Yeah.
In a Daubert motion, you make allegations. Prosecutors make allegations. But those allegations, I have to refute. But you don't take those allegations as true because guess what? They've got to prove it as well. In other words, they can't throw, some article up there and say, okay, Judge, guess what? You have to believe that article. It doesn't work that way. The problem that they have is that they don't have an expert that's going to be able to say that this particular demonstrative evidence that we're introducing, that there's anything wrong with it. It's demonstrative. It's trying to give the court, the jury, some indication of what silhouetting is. And so he's wrong. Somehow he thinks, yes, you can make an allegation and it shifts the burden. But just because it makes the allegation doesn't mean that you have to, the judge has to conclude that what he's given you in those allegations are true. What we've done in sworn testimony is we have refuted and we have substantiated the reliability of the silhouetting process that we intend to introduce.
All right. As far as the Daubert motion regarding Dr. Knox, the state's indicating that defense failed to refute your allegations about the accuracy of the human eye versus the camera, primarily, that's one, and then that there's no accurate recreation of the backlighting.
Correct, that's the two.
And defense is indicating that they want to use these photos as demonstrative aids.
Which is what Pierce and Brown goes to.
Right, and so I'm glad you brought that up. On Pierce, the state was allowed to use styrofoam heads as demonstrative.
Kind of like we did with the skeleton.
Yeah, but a little more involved, without a doubt. I mean, they stabbed it to recreate the stabbing of the crime. My question on that, well, I got a lot of questions. I'm not positive that the defense has not satisfied Daubert. the statute. The prongs in the statute, there's 3 basically, but Daubert, obviously, there's 4, but statute is just codified Daubert. So how is Pierce distinguished from what the defense wants to do here? How is it okay, how is it a styrofoam head is similar enough, but these, and I'll say, you know, in scientific approach to these photos, you know, obviously neither of them are the exact recreation. Clearly in Pierce you couldn't have that, but so, you know, you gotta go there. They're not the exact recreation. How is Pierce different from what we've got here? Now, I understand the backlighting question. It looks like there's several different backlighting issues addressed in the photos. But my first question is, how is the Daubert requirements not satisfied by Dr. Knox? Which prong is lacking?
The prong that is lacking is that the camera lens can't capture an image exactly like an eye can. And he admits that in the depot.
Okay.
And just so that, I know it's a little tricky, the styrofoam head is brown, just so the record's clear.
Oh, okay, sorry. Thanks. No, I appreciate that. I
I
was looking for it again in Pierce and I didn't see it. Thank you. I appreciate that.
Right, and
Yeah.
if you want me to comment on that, I will, but you had another question about how they don't meet, and that is I apologize for saying
It's
that, and that
okay.
is the issue, because their own witness indicates that it doesn't. And then he goes on to say, but this is what Reeves had an opportunity to say. So he agrees that the lens is not like the eye. He agrees that he can't capture it, but he wants to tell the jury, this is what Reeves could see. This is his perception. And so there, it's a problem upon a problem. That's why I ran the motion to keep it out, because that is not, he can't say that is what Reeves can say. He submitted that in his depot.
Okay.
So I ran the motion for the sole purpose of making sure the court understands that we have an issue under Daubert. That's the scientific part, the camera lens, how it works, how it functions, how it captures light in an image. It's not like the eye. And their own expert admits it's not. So that's why it should come out.
And I read your articles, and I understand the defense's argument about that. It's been a little while since I read the articles. It does seem to be almost common sense and pretty straightforward in the articles that, you know, a camera is just not as good as an eye. What about that, Mr. Escobar? Is that what Dr. Knox is going to testify about?
Oh yeah, he's never going to say that the camera can capture exactly what the eye does, but we have that phenomena in photos.
Sure.
You know, because remember the standard for photos is fairly inaccurate. It doesn't say exactly what the eye. So then what you're doing then, if we're going to have that prohibition, let's not introduce any photos. Because if in fact the eye is seeing something different and is not exact to what the photo is capturing, then we've got a big problem. That's the problem, is that in our world, in our scientific world, no, a camera can never capture exactly what the eye could capture. But if it fairly and accurately depicts what is taking place, then that is sufficient under the law to have it introduced. And all we're doing in a demonstrative capacity is we're not saying, this is exactly what Mr. Reeves saw throughout the entire encounter. What we're saying is, hey, this is the backlighting effect that takes place when you have a backlight on an object, a human being or a mannequin, standing in front of Mr. Reeves. This is what you could possibly expect under the circumstances. And that's what Knox is going to say. He's not going to say what he just told you that Knox was going to say. He is not going to say that. I realize that, you know, where Mr. Morton gets a lot of his concern is through his own questions. And I don't fault him for that, because he's asking Mr. Knox, well, Mr. Knox, you know, what is your personal opinion about it? And Mr. Knox is going to say, well, you know, I think that based upon the size of the mannequin and based upon, you know, the lighting that was being, that's probably what Mr. Reeves was actually seeing at the time. But, you know, and then he puts that in his motion for a motion in limine. We were never going to ask that. Just like we were never going to ask, you know, Bedard some of the questions that, you know, he thought we were going to ask, but he just asked that in depositions. And so, you know, if you want Bedard's, you know, honest opinion, he's going to give it to you, but it doesn't necessarily mean it's admissible. So you've got to look at this issue of the camera versus the eye in the same light as we look as a camera and a photo. And for as long as I've been practicing law, we have allowed photos to come in under that particular standard because, yes, I think Mr. Knox told you that it's impossible for this machine to, you know, capture it to 100% certainty, but it's pretty close. I can tell you that.
Okay, and I understand your argument. Of course, we all rely on the photos and probably state more than anyone else. However, it's not typically from the standpoint of someone's perception.
But you know, this is demonstrative. We're not introducing
I know,
it.
I
It's a
know.
little bit, it's a relaxed standard.
I know, and I'm keeping that in mind. So, I think that the prongs of the statute have been met through Mr. Knox's testimony. And I feel that any issues that state is complaining of can be addressed on cross. And they are demonstrative, they're not going back. And I think these are a little bit different than the previews playing, in that what I'm seeing is that there are various different lightings. And again, that issue can be developed on cross. And as long as the testimony isn't elicited that this is what Mr. Reeves saw definitively, then I'm not seeing a great distinction between this case and the Brown case, where, you know, we all know that demonstratives are just that, and to exclude a defense witness's presentation when after reviewing everything, I feel that the prongs of Daubert have been met. I don't have a strong basis to do so, other than the argument about the eye versus the camera, and that is compelling, which is why Dr. Knox will not be able to testify that this is exactly what this is what Mr. Reeves saw, and that's not going to happen, right?
That's not going to happen.
I think it's a fair and accurate portrayal of something that this expert is able to testify about. I don't think it's misleading to the jury. So I'm gonna rule in favor of the defense on that one.
Judge, just so that you know, for Mr. Knox, we're not going to elicit from him any type of, trajectory or ballistics, even though he's qualified. I think Glenn will agree with me that he's very qualified to do that. We're not gonna do that because we don't think it's needed at this point in this trial. We don't think that's gonna be a lengthy process, and I'm not sure, this is not a whodunit, it's.
Right, exactly. I don't know why that would aid the jury in their decision.
The other issue with Mr. Knox was his interpretation of the video. I've run that by Mr. Escobar. He's assured me that he's not going to do a running narrative of
Okay.
The only thing that we're gonna talk on the video, and we've talked about this, is that there was an issue that came up on either illuminating or reflective. It could have been the phone, it could have been the shoe, and what Mr. Knox tried to do with Mr. Koenig in order to try to find the source of those lights. And that's about the only thing, but he had to look at the video in order to see that there was either a reflective or illuminating light that we had to find out the source of.
Okay.
Judge, my discussion with Mr. Escobar was that they went into Cop Theater and Mr. Knox was told there is an issue about whether or not something in the video was illuminating or reflecting. Not that he's viewed it or whatever, because he's already testified at the immunity hearing. I saw a reflection and I saw something illuminating and I saw something that was a shoot. So he's already said, I think there's two things. And Mr. Escobar, throughout the whole trial, to his credit, he's been very careful to say illuminating or reflecting, not is one or what the object is. So I think if it's couched, even leading if you want, that a point of interest while we're here was to determine whether or not a point of interest in the video was either illuminating or reflecting. That would be the proper way to do it. I'm suggesting to the court would be the proper way to do it. And then he can say, yeah, we tried to do it and we couldn't do it. So, he does say, I watched the video and I saw this and you know what I mean? So I think we can do it very cleanly, like we have been doing the entire trial that way, and I don't have a problem with that. But also during his previous testimony, he went over, I didn't see this, I didn't see that, I didn't see the hand up, I didn't see the yelling. There's like 12 things that they went through. So I'm being told that he's not going to do anything with the video about what he saw or he didn't see.
Okay.
So with that understanding, we don't have to argue that part. We don't have to argue the trajectory. Mr. Escobar can tell me tomorrow if he's going to put in those other photos that he doesn't know if he's going to use, and you've already ruled on the magnet. So the only thing we have left with Knox is the seating photos. Our argument is the same, is dim 1, dim 2, camera doesn't affect the eye.
Judge, I'm gonna save him some breath there. I'm not gonna do it.
Okay.
I'm not gonna do that, but I do want to talk about this issue of the illuminating or reflective. We presented to Mr. Knox the fact that there was an issue here as to whether that illuminating or reflective light was either a phone or a shoe. Could be either. I'm the first one to tell you that, it could be either. Part of the problem that we have in trying to determine whether it was one or the other, is because everything was dismantled over there in the form of the actual machinery. Had they not, we feel very comfortable that we would have been able to tell this court what it was. The problem is that I don't want to hide that fact that we were trying to determine whether that reflective or illuminating light was either a shoe or a phone, because that's the truth. And Mr. Knox, in his crime scene investigation, had to consider those two items as whether they were or they were not. So I'm not gonna get up to this jury and say, well, we had a source that we were concerned about, which was either reflective or illuminating, and not tell them what those two sources were that we were concerned about. Those were the only two sources that we were concerned about, and so that's the truth. And so I'm not going to tell this court that I'm gonna get up there and say, you know, I've been very good, I think, at making sure with Mr. Koenig that, you know, I was gonna be identifying reflective, illuminating. Because although Koenig was there to make sure that everything was gonna be done videography-wise, it was really Knox and Lacey, which was Mr. Koenig's partner, that were instrumental in setting everything up for that very late night that we were 2 o'clock in the morning at the Cobb Theater. So I don't see any harm in me, in Mr. Knox saying, you know, that, you know, he was trying to find out whether the source of reflective or illuminating light had anything to do with a shoe or a phone, because that's the truth. That's exactly what we were trying to figure out.
What about that, Mr. Martin?
We can be here all day, make a decision, Judge.
I think that is fine. It has been clear throughout the trial, and I thought maybe I've just imagined it, but I think I've heard that it might have been a shoe or it might have been a phone somewhere, sometime. Haven't I?
It's always been, we went through great lengths at both the prosecution and the defense. That's been the
Okay.
issue.
So I think that's fair, that's what he was trying to do and was unable to do so.
And Judge, let's assume that it's a shoe. It doesn't refute, this is the crazy thing, it doesn't refute that the phone didn't fly, because if the phone was flying with the black facing the camera, you wouldn't see it. And if the screen of the phone at the time it was flying, you know, it wasn't illuminated, you ain't gonna see it either.
Right.
So it's not like, you know, there's this incredible, you know, issue that we could resolve. We could have resolved it, but we weren't able because of the DVRs.
Okay. All right, one last real quick thing that I neglected to say about the photos that I agree to allow as demonstratives. The red line, I see in some of them it's very prominent,
Yes, ma'am.
but most of them,
Just the yellow tab ones, Judge.
yeah, there's,
Your Honor, can we have Mr. Knox say that had nothing to do, or the only reason he was doing that, it's my understanding, was that, you know, he wanted to make sure that the positioning, because I was there, and Mr. Michaels was there, we wanted to make sure that the positioning of Mr. Oulson would have been in the different locations. If you look, they've actually put Mr. Oulson in different locations. That's why you see, you know, different effects of the backlighting. And so I think that was only to get a directional, but I can certainly ask Mr. Knox, and Mr. Knox will testify, hey, those things have nothing to do with what I'm testifying about here today.
all right, it's really only prominent in,
Because if not, we're gonna have to, I don't know what
Yeah.
the solution is.
right, I don't,
Judge, it's the impression that it gives. And I know how photographs, once you get back there, they start thinking or whatever, and it doesn't matter what the witness says. So, that's a problem.
Well,
But you've already, you
yeah,
know,
I don't find it to be a problem. The first one in particular, it hardly shows. And so what if they think it's a trajectory, which I personally that wouldn't come to mind, but you're right.
Because it's at an angle, Judge, that's the problem.
I think most people wouldn't give it much thought, and if they did, I don't know. I don't see much, I don't give it any real credence. That's just my findings for the record. I'm not gonna say that the jury absolutely will not take anything from it, but from my humble common sense standpoint, it almost would have to be pointed out in a couple of them to even be seen or
Well, you know
noticed.
this is gonna be up on their whiteboard, it's 4K, it's not gonna be the.
I know,
copy.
I know.
I've got a solution for that, just so the court knows. We're going to have colors made of those. We're going to introduce into evidence the actual colors. We're not going to introduce the thumb drive. The thumb drive is for demonstrative evidence, so, whatever the court, there's some other pieces of evidence there. If you look, I can't introduce that entire thumb drive because it's demonstrative. Some of it is demonstrative. Some of them is evidence. So I'm getting actual photos, replicas of that, to actually introduce, because there's a lot of measurements, as you can see, that I want the jury to have. And so all those measurements that you see there are gonna be in the form of a photo, but we're gonna show it also on the big screen. So what I'm not going to introduce into evidence is the demonstrative evidence of the mannequins. That's just gonna be on the thumb drive.
We haven't even discussed that. I was led to believe this whole thing is demonstrative, and it's on a flash drive, he's gonna use it, so.
How can measurements be demonstrative?
I don't see any measurements in here.
Yeah,
Yeah, there are.
Yeah, there are. There are
In
measurements.
the very beginning,
Measurements can't be demonstrative.
well, the presentation is demonstrative. There's measurement pictures, there's pictures of, the right hand of Chad Oulson, there's pictures of the fingers, there's pictures of Indio, pictures, entries,
So Judge, this is what I told him about the pictures of the wounds. Mr. Knox is highly qualified to give trajectory, to talk about stippling, to talk about all that stuff. I don't want to dismantle this PowerPoint if I don't need to. And so because I don't want to dismantle the PowerPoint, I told him, I said, look, I'm not going to go through all this trajectory, I'm not going to go through this ballistics, but these pictures are already in evidence through him. So that they're harmless. They're harmless. Knox is not going to get up there and say, well, let me tell you about this wound. No, it's just part of the pictures that he considered in doing his crime scene reconstruction. So I told him, I said, you want those pictures out? Then I'll have Knox do his entire ballistics and reconstruction, and we'll put it on. I don't think it's necessary for my case, and I've taken that position. But we can't fight about things that are already in evidence that he introduced himself. It makes no sense.
my whole argument's been the mannequin pictures. I'm not arguing,
Right, the other stuff,
if he has other pictures that he's gonna put in, fine, but I didn't think the PowerPoint was going to go in as evidence. That's
No,
what
it's
I got
not.
from it.
It's not. It's demonstrative, but I'm gonna use photos from the PowerPoint on the measurements that I am gonna get in. And he's gonna lay the proper predicate and off we go.
Yeah, that's fine.
all right, all right. There are no measurements in this stack,
No, Your Honor.
not that I can see. So,
They're,
We set you up for failure, and I apologize.
thank you.
May I take this back?
Yes, you can have that back.
3.81, is that?
This is mine, so I'll put it back.
Back seat, or is that a-
Oh, yeah, I got it. Okay, so yeah, this is,
Did you get the measurement ones?
yeah,
I had
okay,
a question about one of those.
now I see the measurements.
yeah.
Okay,
And those were all that he took himself with us there at the Cobb Theater.
that the state failed to take, that the
They took some-
sheriff's
and-
office failed to take any measurements. Isn't
in
that right?
honesty-
Were you gonna bring that up
No,
again?
Your Honor, in honesty, they did take some measurements, maybe most of them a little late, but they did take measurements.
You didn't put them in.
I have a question on
I know.
on two of those pictures with the measurements.
Okay,
I'm just going from memory. One of them was a demonstration of someone leaning back in the chair, obviously to simulate Mr. Oulson putting his arm on the chair and leaning back, and what the distance would be if the chair leaned all the way forward. So my objection with that would be, and I wasn't here for the discussion about the dummies and silhouettes, but I would think that all of those arguments would be the same, which is very similar to the movie trailers, which is, this is an attempt to recreate a scene that can't be recreated. You can't figure angles, you can't figure where everybody was, you can't determine the lighting conditions, you can't determine the sound. There's no sound for this argument, but it goes back to recreating the entire environment in the theater. So the demonstration of whoever that is, I'm assuming it's Mr. Knox, of pushing back on the seat, we don't know how far Mr. Oulson was back. He could have just been touching the seat. So it gives the jury the impression that the distance has been closed based on that particular picture. So I would say that picture should not be allowed. The other picture, I can't remember if it was 3 feet 8 inches, and it shows distance from one chair to another chair. I don't know if that was to represent Chad Oulson's chair distance to Vivian Reeves's distance, or it was a diagonal measurement, so it went from Chad Oulson's chair all the way across the stripe of the left-hand side of Curtis Reeves's face. I don't remember if I actually even saw a measurement for that, which would be curious, but if there's one in there, I'd like to take a look at it. But, you know, any of these things, I understand they're demonstrative aids, but demonstrative aids still cannot be misleading under 403. No matter what, it has to pass 403. And again, I wasn't here for the knots and the silhouette argument, but, you know, just to add that to the record, you know, if we're trying to simulate how the defendant viewed something through a camera that can't simulate the human eye, I would certainly think, and unfortunately, I wasn't here, so I don't know if there's a 403 argument made. But how you can have someone sit in a seat with a camera and then make an argument to the jury that looking at this photograph adequately represents what Mr. Reeves observed of a silhouette of a mannequin that doesn't have the same shape and design of Mr. Oulson. I just don't see how that would aid the jury in anything. If anything, it would mislead and confuse the jury, but it's not so similar to either of the people. I mean, I would submit that if we took a picture and sat down with a camera and said, look how easy it is to see Mr. Oulson, someone would say, that's crazy, you can't replicate how someone saw Mr. Oulson on that particular day. You couldn't do that, and I would agree, which is why I would never try to do that.
Judge, getting back to the measurements, and I, with all due respect to the prosecution, their crime scene investigation in this case was a train wreck. They didn't take proper measurements, they didn't get any guidance, and so now what Mr. Knox is going to talk about is this is what you have to do in a crime scene, because you have to take pictures of measurements, not only in the seat in the upright position, which we did, and we're going to introduce that, but we're going to take pictures of that seat when you're pushing it back, because if you remember, there's some testimony here that Mr. Oulson is coming over the seat. And so if he's coming over the seat, and if you remember, there's even testimony that they didn't even know if the seat was down or if the seat was up. In other words, some of those seats pop up. And so you have to take all these measurements so that the jury understands what the measurements are for every possible scenario. It's the jury that's going to decide, you know, whether in fact there were certain inches that were available for Mr. Oulson to strike, you know, Mr. Reeves. We know that certainly he got really close because Mr. Reeves had a popcorn in his hand and he grabbed that popcorn from Mr. Reeves' hand and shoved it in his face. So those measurements, I don't know, you know, what Mr. Rosenwasser is talking about, because in every case that I've had, crime scene comes in, they do all the measurements. The more measurements, the better. Because these folks here need to know the layout, they need to know the measurements of that theater so that they can then determine what really took place in this case. So none of those measurements are prejudicial. We've got measurements of the seat up, we've got measurements of the seat down, we've got measurements of the back upright, the seat up, the seat down. We've got it every which way possible, because we're not telling this jury, hey, listen, you know, this is exactly what was happening at this point in time, but we're giving them the parameters of space. Space in self-defense cases is critical. Now, Mr. Rosenwasser, in opening statements, you would think that the distance between Mr. Reeves and Mr. Oulson was half a football field, because he was talking way in the row over there. You know what I mean? Well, it's not way in the row over there. It's a very, very tight space, and the jury needs to know the diameter of the entire theater. In fact, you know, Mr. Martin and I actually got actual specs, engineering plans for that particular theater that was given to us by the theater. So, it is what it is. I frankly have never had a prosecutor argue against measurements within the theater and within the space of where the incident happened, because that happens all the time. I've been doing this for 37 years. I can't imagine any murder case that I've had where that hasn't happened, other than this one. And I think, you know, we showed the court why we thought that this crime scene investigation was not done appropriately.
I wasn't objecting to all of them, it was that one. I mean, of course we would want the measurements in.
Well,
I mean,
that seat
I was
goes
just saying
back.
about that one.
That seat goes back, so you don't want to tell the jury, don't tell the jury the seat goes back.
You can't say how far the seat was back. You can't mislead the jury.
Sounds like cross-examination to me, but that's just me.
Yeah, I see we've got a 3 foot 8 inch and a 3 foot 2.5 inch. Basically the same kind of thing.
And there's gonna be many more, Judge, that we're gonna be introducing with Mr. Knox. They have them all. They have all of Mr. Knox's measurements, so it's.
All right, this all sounds like contemporaneous objections, because it's pretty specific, but in general, I don't see a problem with it. From a Daubert standpoint or a 403 standpoint, what I'm looking at here. I don't think it's confusing, and if there is clarification needed, that's can certainly be accomplished on cross, I would think. So I don't see an issue with these photos. All right, what else?
I'll prepare an order for the Daubert motion dealing with that issue. The mannequins was a separate motion in limine filed in 2017.
Okay,
I'll prepare an order for that. I'll withhold on the order on the other motion in limine filed in 2017 regarding the seating, and or I can do an order that says that Mr. Escobar says he's not going to use them, therefore it's moot.
well, yeah, because that's what I'm concerned about, because, I mean, my order on the Knox-Daubert motion is going to be similar to Judge Lewis's in that, you know, it's not very specific, but primarily it's in recognition of the things that Mr. Escobar is not going to elicit, so I don't need to.
Right, so I could do the Daubert as being, the video is moot, the trajectory is moot, all these are moot. The only thing that was heard was the backlighting and
Backlighting.
denied. I mean,
Right,
that's all we need.
Right.
It was denied and that's
Right.
reserved for appellate. So I'll do it that way, and then with the motion eliminating regarding the backlighting is a separate issue.
okay.
It's out there, that'll be denied, so preserved, and then with the seating, if Mr. Escobar says he's not gonna use them, then, that can be reflected that it was moved.
Okay,
What seating, what do you mean seating?
You told me you weren't gonna use the, general seating area.
Oh, you're talking about the ones where it was the lighting conditions and
Yeah.
seating, I'm not using, but it's really lighting conditions, that's the issue there.
That's why I said, the general seating lighting, my second motion
Yeah.
eliminating.
Yeah,
I'll put in the order that in open court, not gonna use, therefore it's moot. And that will have that
okay,
order taking care of that.
all right, excellent. Anything else today?
Yeah, I gotta review a video.
I know,
Among other things.
I know. Yeah,
I don't think, if you, I think maybe Mr. Michaels and I can talk just a little bit more about Mr. Bedard.
okay,
We're close. My math is probably a little better than a lot of individuals in this room, so we're more than halfway there.
I like
so-
that.
he just threw me under the bus.
No. We are more, there are a couple of issues, and there may be issues we may have to discuss with the
Okay.
board. I'm gonna talk to my expert this evening,
Okay,
just to get his input on it. He's an expert,
all right,
and he's testified, and then we can, whatever we can agree on, then we'll address it with the court.
All right. And
He's
I'm-
not testifying tomorrow, correct?
But, oh, yeah,
Probably late.
yeah.
Well, then that's the problem, we've got to have these issues resolved.
Well, we can work
We
on
can do it
it
in the
lunch,
morning.
or lunch,
When?
Or lunch, that's fine.
lunch, yeah.
Lunch.
We expect that tomorrow, just so the court knows our schedule, Foley, Knox, and Bedard.
Okay.
I don't think we'll get past this.
Right, I think maybe Foley and some Knox before lunch,
That's what I'm hoping.
and then
Knox and-
Knox and Bedard in the afternoon.
And what I'll do this evening, once I'm able to speak to Mr. Bedard, I'll go ahead and shoot Mr. Martin an email,
Okay,
because I know what his main concerns are, and the ones that we kind of are, I know the ones that we can agree on right now. Other ones I told Mr. Martin I was unsure of, I'm pretty sure we can agree on. There's probably just two issues. One has to do with an objection to the testimony being cumulative as it refers to self-efficacy because of Donnie Cohen, so I want to be able to flesh
Okay.
that out more and I
okay,
can articulate it better. Another issue has to do with some of the differences between instructing police officers, the force continuum, and those kind of things that the court heard. Well, that's right, it was Judge Lewis, I think, heard that motion, but anyway, and so those are things that, we're not too far apart,
okay.
but we're not close enough on those, so we may have to discuss it.
I have reviewed the entire transcript
Okay.
of Dr. Bedard's testimony for the Daubert, so,
And so did I, and I provided you not only my motion, but a reply,
right,
because there was no oral arguments.
right,
Right, and it was granted, but again, subject to
Right.
evidentiary issues,
Right.
like, he's not gonna get up there and say, I
right,
looked at, Mr. Reeves was reasonable because of my training and his training, or I looked at the video, I mean, all that stuff, we agree on the big stuff.
Right.
It's that cumulative and maybe some other issues that we'll.
okay, that's good that you're
Okay.
getting close. All right, so we can plan on doing that at lunch tomorrow, so maybe bring your lunches and we can have a brief lunch and,
Okey-doke.
some.
We frequent Olga's in the morning.
Yeah, there you go. All right, shall we break for now? I think we've had enough for one day.
Yes, Your Honor.
All right, thank you, everybody. We'll see you in the morning, 8:30. This is, Mr. Martin, you've got stuff up here. I don't need that, it's off, we're off. Thanks.